Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Everyone, please be seated. We are here today for the submission of 3 cases. The first case, Iowa Supreme Court Attorney Disciplinary Board versus Yang, is hereby submitted without oral argument. And the case of Roberts versus Roberts is also submitted without oral argument. This afternoon, we're going to hear an oral argument for one case. But before I do that, my colleagues said, are you going to make us do the high school thing? Yes, I am. I know there's a bunch of kids here from Bergman Academy. Raise your hand if you're Bergman Academy. Raise them high. Good job. And am I correct? It's K through 8 is the school, but it looks like you guys are probably the upper level of the school. Okay, thank you for being here. And I'm going to throw my colleagues for a loop. Now we're going to talk about our middle school years. Where do we go to middle school? That might be different. Because no matter what our career path is, everyone has to go to high school, graduate from high school, and then go some more. So I'm Susie Christensen, the chief. I'm from Harlan, Iowa. And in 8th grade, I went to junior high, which was 7 through 9, and now they call it middle school, 6 through 8. Things change. And I'm going to go in order of seniority. It goes right, left, right, left, right, left. Not by age, seniority.
I'm Tom Waterman. I went to Bettendorf Middle School.
I'm Ed Mansfield. I grew up in Lexington, Massachusetts, so I'm an Iowan by choice. And I went through the Lexington school system. Lexington is where the American Revolution started. So every single school there is named after somebody who fought at the Battle of Lexington. And so I went to William Diamond Middle School. I don't know who William Diamond is, but I know that in 1775 he was pretty important. So,
good afternoon. I'm Christopher McDonald. I went to McCombs Middle School here in Des Moines. I don't know who Mr. McCombs was, actually. And then 2 of my kids went to Bergman Academy through 5th grade. So, welcome, Bergman.
Good afternoon, I'm Dana Oxley. I grew up in a small town, so we just called our middle school Greenfield Middle School. Actually, it was junior high then. It was a junior high school.
I'm Matt McDermott. I went to middle school in Carroll, Iowa as part of the Kemper High School group. I was at St. Angela's Academy.
I'm David May. I am also an Iowan by choice. I grew up in Kirksville, Missouri, and I went to Kirksville Junior High.
All right, now we're going to do our jobs. We went to school beyond junior high. We got to keep going here. Okay, so for the appellant, I believe Payton Kitterman will be arguing. That's correct. Thank you. They pretend like they are annoyed by me. He just said, you forgot to ask them. Tell us where you went to middle school.
I went to K through 12 at Lisbon Community School. Anything else? All righty. Can't forget this time. May it please the court. Counsel, my name is Payton Kitterman, and I'm a student attorney at the Drake Legal Clinic. Everybody agrees that this court should reverse, so why are we here? We are here for 3 reasons. First, to get an order so KC can pay Dr. Tracy Thomas, a board-certified forensic psychologist, for her work. Second, to ask this court to adopt Pierce v. Nelson as the test for reasonable compensation. And third, to ensure youth have meaningful access to defensive resources.
I want to talk about that third one first. That youth lens, you're calling it? Don't you think there's enough protections in our code? I mean, the entire Chapter 232 is protective in nature for children. They get, for example, the most, you could be convicted of a pretty high crime, even a felony, as a juvenile, if you haven't been waived up, and the most time you can serve is 2 days. That's just one example. Isn't what we're talking about more, I mean, how much a person gets paid, that really shouldn't have anything to do with a kid, should it? Maybe just the determination that they need an expert, but not how much to pay them.
Yes, I would cite to State v. Lyle that children are constitutionally different and their right to expert compensation is a constitutional mandate. The fact that children are constitutionally different isn't like a new test. It just fits under the test, such as Pierce v. Nelson and the 7th catch-all factor. It doesn't require this different test. It simply requires the consideration of the unique circumstances for youth. Children need meaningful access to their constitutional right to expert assistance, and may be different than what an older adult would need. Specifically here for KC, evidence related to his youth included intellectual functioning at the age of a younger child, adverse childhood experiences, lack of a driver's license, and limited financial resources.
What about someone with disability, physical disability? Do we need to start looking at something with the lens of a person who's physically disabled? Why can't we just include that in part of our normal weighing of the issues? Why do we have to have a special lens?
The special lens is just important so that the courts know that they're looking at what a child needs to meaningfully access their expert assistance. The juvenile court should have considered that information about KC. Again, the court found that it was not reasonable for Dr. Thomas to drive to Des Moines when KC could drive himself. That was just simply not true. KC did not have a driver's license and did not drive. And as his juvenile court officer offered at the hearing, transportation barriers already existed for him to get to his other services. Dr. Thomas's requested expert fees were reasonable under the Pierce test, and that is why this court should reverse and remand for the full expert fees. And then I want to go back. Yes.
The constitutional issue, if both sides agree there was an abuse of discretion on the factual record here, she should get paid in full. Why should we not apply the constitutional avoidance doctrine?
That if this court does reverse because of the reasonableness determination and finding that the court erred, it does not need to reach the constitutional issues because of the doctrine of constitutional avoidance. But if it does, this court should decide those issues. And also, it is important, even in any reasonableness determinations along the lines of Simmons v. State Public Defender, that this court recognize the constitutional icebergs involved in this case.
Was the constitutional argument or claim that's being made here preserved? As I read the district court's ruling, it's not jumping out to me.
Yes, error was preserved. We acknowledge that the important constitutional issues should not be raised at the final hour, but that did not happen in this case. In Casey's motion before the court on September 8th, he raised his due process concerns for the first time. And then again on September 18th, he raised his equal protection issues for the first time as well. He then cross-referenced these filings in his subsequent motions before the court. The order of the juvenile court necessarily found that $4,590 was enough to satisfy his due process and equal protection rights.
For you. The red brief talks about the Hulse case, and I believe in your brief you guys said that case actually helps us. Can you persuade me that Hulse actually helps your position?
Yes, we believe that under Hulse, Casey still is, that the compensation for Dr. Thomas is still reasonable. However, we think that the test should be Pierce and not Hulse. I believe our mention of Hulse was just to give this court options, but we would ask that this court apply Pierce instead. Hulse relates to the reasonable compensation for attorneys and not experts. Judges are attorneys and have the knowledge and experience to assess reasonable fees for them, but most judges are not board-certified forensic psychologists, so their expertise is lacking in what is reasonable for an expert fees. So to the extent that Hulse applies at all, we would just say that it stands for the proposition that no discount of compensation is required for an attorney's representation of the poor or an expert's work for the poor.
Let me ask you, I believe this doctor was charging, it's about $300 an hour, is that?
$40 an hour.
And that's a lot more than a lot of attorneys get paid per hour. And it seems like your position, and maybe everybody's position, is that we should largely just let the experts tell us what a reasonable fee is. And if all of the experts are sort of charging at a very high level, that we should kind of be bound by that. And that because this bill sort of fit among the other options, 7 or 8 or 9,000 that they all were, that we have to accept that. And I worry a little bit about the idea that we give the person being paid or the group being paid sort of unlimited discretion to decide how much they should be paid. And can you kind of help me with that?
Yeah, I would say that, first of all, the juvenile court below did not indicate that it took issue with the rate of Dr. Thomas. And then I would say it's important to note that the other two available experts, like you said, estimated $8,000 and $10,000 for their work. And so that is just a factor under Pierce v. Nelson to be considered in assessing the reasonableness of fees. Dr. Thomas, in her testimony, I believe, noted that waiver evaluations are so extensive and they take a lot of time and they involve a lot of work for the expert, because what they're doing is they're looking into the past of the juvenile, of the youth, and they're trying to predict their future for rehabilitation and what's in the best interest of them. So it's not so much just considering what all the experts are telling us, but it's also considering the work that they need to do.
Unreasonable for the juvenile court to be concerned about the travel time aspect. I think that was one piece that the sort of I could relate to, that maybe paying $300 an hour for the expert to travel when there might have been other alternatives. Can you explore that for me?
First of all, one of the original concerns, which was remedied prior to the hearing, or at hearing, was that the court took issue with the travel time to testify. The expert did not testify. They testify in person. They did testify virtually.
Pause you on that part of your answer. If your client had actually wanted the expert to testify in person, would your client have had the right to demand that? Or in this new world of remote testimony, does your client have to accept the offer to testify remotely?
I would say it would again go to a reasonableness evaluation, and that is not the issue before the court because the expert did testify virtually, but that would be up to the juvenile courts in the future to determine whether it was reasonable to have an expert testify in person. And there you could consider how much more use you could get out of seeing the expert in person and whether that would be helpful for the court in making its determination.
Justice May's question about whether the district court just has to defer to the actual fee that the expert invoices. You listed all the work that the expert did, et cetera, but does the district court have discretion to say, for example, I find this fee in this kind of case to be unreasonable, let's say the rate, and I'm only willing to compensate you at $200 an hour versus $340, but I will allow compensation for all the work actually performed? And if not, why not?
I would say that the juvenile court may have discretion on that, but it still takes a reasonableness determination. They must still look at the unique circumstances and facts of the case. And in this case, it was reasonable to charge $340, which is not even the issue before the court today. And it was reasonable to charge $7,791.20.
I mean, that's just an assertion. I mean, maybe the district court judge obviously thought it was not reasonable because she lowered the fee. So what is the objective assessment by which we can determine whether or not the fee is reasonable?
That takes me to Pierce v. Nelson. Reasonable compensation is the standard here, and Pierce simply provides a framework and 7 factors for the district courts to consider when assessing reasonableness of fees. This framework can lead to more equitable and consistent outcomes for the juvenile courts. The state public defender, which oversees the Indigent Defense Fund, agrees that Pierce endorses the Pierce test as well.
So let me ask you one question about how this is going to work. Let's say we agree with you that the Pierce test should apply. At that point, do we apply the Pierce test, or should we send this back to the district judge with instructions to apply it in the first instance?
In this case, we would ask this court to reverse and remand with instructions for the full fees. This court, KC presented the Pierce test as this test for assessing reasonableness as early as September 18th, and the juvenile court did not acknowledge that test or use those factors. It has now been 490 days since Dr. Thomas completed her work, and KC has an outstanding debt to her that he has not been able to pay in that time. Pierce was a civil case, and while the context,
My questions is, where does it stand right now? If we were to say, no, we're just going to keep the order as it was, who's responsible for that remaining amount owing to that expert?
I'm not sure if the record is clear on that, but Dr. Thomas did provide her services to KC, and now he does not have the state funding to adequately compensate her. Now I want to talk about my third point. Here, this case raises concerns about access to justice. Unjustifiably capped expert fees can have a drastic impact on indigent juvenile defense and waiver hearings. The pool of experts with the requisite training and knowledge in juvenile waiver evaluations is already so small, as evidenced by KC's attempts to secure a forensic psychologist. As the state public defender notes in their amicus brief, the number of experts will only get smaller if there is no guarantee of payment for their services. This is especially troublesome in the waiver context, where the stakes for children are high and the need for specialized experts is vital.
Lens thing again, right? Is that what you're talking about? You said third point. Are you the juvenile lens?
Now I'm talking more about the effects that maintaining this arbitrary fee cap will have for children in the future.
Also, is this also in support of your juvenile lens argument?
I see them as separate. I also wanted to talk about how this will affect court-appointed attorneys as well. This will make it more difficult for them to provide effective and competent representation, especially if a client's defense rests upon experts. Studies cited by the Juvenile Law Center in their brief also show that youth may make decisions against their interest when faced with the risk of legal debt. Uncertainty about payment may deter youth from hiring experts necessary for the defense. While Casey was able to use an expert in his case, this court should reverse the juvenile court's ruling to prevent future prejudice to children seeking expert assistance in waiver cases. In conclusion, Casey requests that this court reverse and remand with instructions to approve the full expert fees. This court should also adopt the modified Pierce v. Nelson test. Thank you.
Miller, middle school.
I made a note, so I would have remembered, but thanks for the reminder. I grew up in St. Louis, and I went to Wydown Middle School for 6th through 8th grade. I would like to start by specifically explaining why I think the district court abused its discretion, and then talk about the practicalities of how this should work. I think the district court abused its discretion in 2 ways. I think that the number it arrived at isn't sufficiently explained to understand how the court got there, and that problem is exacerbated by the second abuse of discretion, which is relying on facts that aren't supported by the record. I think we'd see a bit of a different case if the district court had said, I think this fee in my experience is too high of a rate, or these hours are too many. for these reasons, and that's why I'm reducing the fee. And I think that type of analysis, even if it wasn't down to the minute, would be consistent with the case law and a proper exercise of discretion. I think that the reasons the court gave for reducing the fee, there were 4 of them. We've talked about, or you all talked about the travel for consultation, and I think that that reduction supported by the record, the district court could do that. There could have been another way to, use Zoom or perhaps someone else drive the youth to Ames for the consultation. The second was travel for testimony. That didn't happen. And then on the motion to reconsider, the court just reincorporated its prior ruling, so that was no longer a valid basis for the exercise of discretion. The third factor was that there weren't voluminous records to review. The expert had speculated or guessed that they would need 2 hours to review the records. When the motion to reconsider was filed, there had been a bill where they had reviewed records for 2 hours. Before the final ruling denying the fee request, their waiver report had been filed where the expert listed the 9 kind of sources of documents they reviewed. The waiver order noted the thorough job the court did in reviewing the records, but then didn't offer any explanation to kind of reconcile its first ruling with the ultimate waiver order where it found that the expert reviewed voluminous documents and did a thorough job. And then the final thing is that the original request didn't sufficiently explain the tests to be conducted. But by the time of the motion to reconsider, the juvenile had made the record of the tests to be done and then why they were done.
Your view, Mr. Miller, that the initial objections may have been okay, but they were resolved and therefore the full amount should have been awarded.
Because the subsequent orders just reincorporated the first original order on the expert fee by saying, for the reasons already given, it's denied.
Also seem to be saying, or maybe it's KC's lawyers seem to be saying that the judge needs to kind of do the math for everybody, and we normally don't require that in a civil context when there's a fee application. The judge will give some reasons, knock something off the bill, and we trust, if it looks like it, that the reasons support the reduction.
I completely agree with that, Your Honor, and I think that would be appropriate, but in our view, that wasn't done here. The court didn't sufficiently explain that in its experience, the rate was higher than normal, the hours worked were higher than normal. If that had been the order, I think you would have seen a different litigation posture in this case. I would also note that the way it got here is a bit unusual via certiorari. I think the normal way you would do this would be for the expert or perhaps their court-appointed counsel to submit the fee under the SPD regs. I think the SPD would interpret their regulations to not be allowed to award more than the district court granted, but then you have appeal rights for the claimant and the SPD, and the SBT, who's in charge of the Indigent Defense Fund and has a bit more of an interest in this dispute, could have either granted the full request of the fees or denied them and then litigated that at this point.
Are where we are, the path they took, and it's really, you got to admit, this is odd. I'm having a hard time remembering, which side are you on? Because you pretty much have adopted everything that they have said. They've said, yes, judge abuse your discretion. Yes, the expert should be paid. So I'm trying to think of when we issue an opinion, what is it going to say that's going to be helpful to anyone? When I drill down on this, it seems to me that, the words arbitrary and capricious come across to my mind. I looked at the order that was filed on October 11th by the judge, and correct me if I'm wrong, and you can correct me if I'm wrong, but it kind of seems like there was an intentional delay tactic by the court that really put the kid in a catch-22. I mean, she seemed to actually have been annoyed by anybody even tapping her on the shoulder and asking. So help me understand from the perspective of a court who's writing an opinion on this, when everybody across the board says, yeah, no harm, no foul, go ahead and send it back and pay for it, if that were what we would adopt, what are we actually, are we serving the purpose of an appeal, and what message can we send to the bar and the bench?
So the points that I think I disagree with the juvenile on are that I think a district court has considerable discretion in deciding the amount of fees, and they can rely on their experience and expertise in that area in deciding the amount of fees, but they have to exercise that discretion. If the SPD, thinks that as the administrators of the fund, those factors are appropriate. I don't know that we have a substantial interest in disputing it. They do seem like relatively common sense factors in the Pierce v. Nelson test, but with the understanding that these fee disputes are not going to have a traditional adversarial posture. The state, as a prosecuting entity, has been told by this court not to dispute fee requests. And so the court, I think district courts need to know that they're going to have latitude to exercise their experience and their expertise. And I would say that I think that this court should remand to tell the district court to reconsider and apply whatever test or rules are appropriate. And I don't think this amount is necessarily a problem. I think it's that it's not explained on the facts.
To make is, what message are we sending on the practice of law when you have a judge who's saying, I previously held a hearing, and then puts in italics, at your request, we moved the hearing date. Defense counsel subsequently contacted judicial assistant on 2 separate occasions. Defense counsel has now filed another motion. It sounds like an order that's saying there's been some whining going on. What message can be sent in this opinion? What is the protocol? What's a lawyer supposed to do? It is hard for a lawyer to say to a judge, excuse me, would you please rule? For fear of the judge saying, oh, you betcha, I'll rule today against you. There's that fear. So I kind of think that the motion was quite brave. And what are we to say about that to judges?
I think that this court is in a better position than I am to tell district courts the kind of time frame that they think would be appropriate in kind of under the statutes, that you can't get fees as the expert until the court either approves them beforehand or, there's the mechanism to approve a reasonable fee on the back end, but that does leave a juvenile like Casey in a tough spot. Well, actually, I think it really leaves the expert more in a tough spot because a juvenile can't have these fees assessed against them under the code. But the expert is in a tough spot of saying, well, I'm not going to do the work, in which case you potentially have a constitutional claim, or saying, I'm going to do it and take the risk that I don't get paid, which then could lead to problems with people agreeing to do these things in the future. And so I think that encouraging district courts to rule on these motions expeditiously and understand that there's a practical problem here, that people aren't trying to be difficult, could be useful guidance in terms of like a number of days or something like that. I don't think there's any code provision that provides that. I think, this court is, you would administer the lower courts. And so I think have that authority and would probably be better positioned than I would be to appropriately direct district judges.
Child made every effort they could to obtain a timely decision.
I think that, yes.
Finding of an abuse of discretion, like you say, a super abuse of discretion. Have you ever seen any kind of gradated effort? I'm just concerned about the message that we're sending when everybody agrees, yeah, that was a violation, and we should go backwards. I'm just wondering, how does that help the bar if we just plain say, yeah, and we're not going to talk about the details?
Right. I think as part of an abuse of discretion standard, if a refusal to rule on an issue could potentially be an abuse of discretion. If it had, risen to the level of a constitutional violation, I think that could create an abuse of discretion. I don't know that. That's kind of an interesting question. If there's an amount of time that could pass that's an abuse of discretion in and of itself if you don't rule. I've never seen that. I guess it's possible.
To the case that was cited by the judge, I don't believe she even analyzed it. She just dropped a citation to Hulse. But would you agree with me that it doesn't just talk about compensation, it talks about reasonable compensation?
The code requires the district court to determine what compensation is reasonable. So that's the appropriate thing to be doing, is the amount of compensation that's reasonable. That would, I think, pertain to both the rate of compensation as well as how much work is done. And like we've talked about, some of these factors from Pierce v. Nelson seem, common sense things to apply. What do other people get paid? What do they get paid, in a private practice situation versus, kind of a court-appointed situation? How much time did they do various tasks? Were they necessary? What test does a juvenile need versus an adult? Those things can all come into play, but ultimately the question is whether or not the award of fees is reasonable.
Question. A few moments ago, and this is why I was starting to ask something, you talked about possibly there being an abuse of discretion because the court sat on the application too long, but it seems like the statute allows for that option, right? And so, I mean, maybe it's the statute that needs to be changed.
Possible. I think this is, like you're saying, Your Honor, kind of unique because the court set potentially a maximum amount of compensation that was lower than the request. And the code contemplates either doing that or on the back end approving a reasonable fee. And I think it could have reconsidered, which Casey asked it to do, and I think that was all appropriate, and it didn't do so, and so it was an abuse of discretion not to. And so that would probably be, I think, how that should be handled. The 2-month delay at the beginning, that does put the expert in a tough spot of whether I'm going to do any work not knowing I get paid, and if they don't do work, then you might have a constitutional violation at that point if no one can be hired.
The juvenile lens argument, whether we should be looking at this issue through a juvenile lens?
To me, that kind of goes to the standard of review, and I think that an abuse of discretion standard is the appropriate standard, not de novo. I think that abuse of discretion is correct because it's a discovery issue. The statute explicitly says that the test is reasonableness. That's a traditional discretionary role of a district court. District courts have expertise in the area of ruling on these issues, and there's nothing about youth, like with sentencing, it's like lack of brain development. But there's nothing about youth that makes $340 reasonable or not. I mean, I guess you could consider as a factor, do people get paid more to test a juvenile versus an adult? I mean, that could be a reasonable consideration, but ultimately, I think that's a discretionary function of a district court. The Court of Appeals has used abuse of discretion review for discovery issues, not granting a investigator in a juvenile case. This court has applied discretionary review of evidentiary issues in a juvenile case. And so I don't think
The district court have in setting what is reasonable. I mean, so I think the juvenile's position is the experts kind of determine it based on what experts charge and what they say other experts charge. And what role does the district court have, let's say, on pushing back on that and saying, no, in our jurisdiction, this is what we're going to consider a reasonable rate, and you need to reset your expectations as an expert? How will that work?
the legislature answered the question by making the standard reasonableness. And so a district court, as I was saying, is a traditional discretionary function. So the district court is determining if the request by an expert based on the materials submitted is reasonable. And they have the discretion to determine that. So they're kind of reviewing or protecting the purse. There's also, again, like the typical way this, I think, normally goes is the expert is supposed to submit a fee request to the state public defender who has administrative rules and is in charge of the funds and the expert in the area also, and then they can grant or deny. But the legislature did specifically give the court the role of determining if a fee is reasonable, and so they exercise that role. And I think it's particularly important because you don't have your traditional adversarial role of the state weighing in on these issues other than in a very unusual circumstance. And when we do, it can get us in trouble. So not only have you said not to, but we don't want to get reversals and things like that for putting our thumb on the scale with funds for defendants. And so it does put the district court in an unusual position where they're not going to have the other side making a robust record. So they need to have the discretion to use their expertise and experience to make sure experts aren't asking for, very high fees. I mean, I think nobody would have a problem saying $1 million an hour is inappropriate.
In this case, though, particularly, I had asked earlier about remand versus us figuring it out. And I was interested in your comment about the SPD and how they can be a filter in the ordinary circumstances. And here we've got the SPD has actually filed a brief, and they just say, pay the full amount. And so do you see any downside to us simply summarily reversing and for payment of the full amount?
Do, and I'm going to expire. Can I answer that question, Your Honor? Thank you. I think that because the appropriate standard is abuse of discretion, this court routinely remands for a district court to exercise its discretion to determine any discretionary function when it abused it, and especially if it promulgates a new test. And so it should do so in the first instance here, although I think that it would be totally available for the expert to request their fees under the administrative rules and consistent with the statutory code provisions in 13b-4.
Goes to my question. Earlier, there's abuse of discretion, there's a super abuse of discretion. The record seems really clear about the efforts. I mean, I think 12 or 13 people they reached out to. 3 got back. They picked the one that was charging the least amount. She shaved her bill for not coming in person. It was down to the fine granules. By the time the final request was made, everything had been done, work had been done. Why do we really need to remand for all of that, when, especially based on some of the comments that I read in the orders and stuff? I think that there are some concerns about tone, perhaps, and the way things were handled.
This court would have the option, if it wanted to remand for a different district judge to consider the motion or the fee request. But I think that the reason is that the district judge presumably has heard these types of requests before. And there's not a transcript, but the Casey's brief suggests that both the district court and prosecutors thought that the fee request was unusually high. If you look at the SPD's brief, they have a list of claims. It's not super clear what that means to me, but if you do a median, if you divide, like one number might be 10,000 for 3 claims. If you then say each claim is a third of that and you do a median, it's roughly 3,000 and some odd dollars. So it's possible this is an unusually high request, and that's why the district court balked at it and just didn't explain why. And so I think that it is appropriate to send it back for the district court to rule on the fee request using its expertise and its judgment based on the record that's made. And so that's what we would ask this court to do. Thank you.
Mr. Kitterman.
May it please the court. First, I would like to clarify my reply to Justice May's question about whether this court should apply Pierce. Yes, this court should adopt and then apply the test. The record is already fully developed, and the juvenile court already had multiple attempts to rule. As a matter of fairness and judicial economy, this court should reverse and remand with instructions to grant the full fees. Then I would like to talk a little bit about some rules and statutes here. The payment of expenses in juvenile proceedings is governed by Iowa Code Section 232.141. That section says that expenses can be paid by the Indigent Defense Fund subject to the limitations of Chapter 815 and the State Public Defender Administrative Rules. Under 815.5 and 815.4, the standard for expert witness compensation is reasonable compensation. Payment requires 2 things. First, court approval to hire the expert before incurring any expense. And second, a court order setting the maximum amount or approving the final bill. That second part's what we're missing here. Although the juvenile court recognized Casey's right to utilize Dr. Thomas's services, it did not approve her final invoice. This writ of certiorari is the only procedural vehicle for Casey to get state funds to pay Dr. Thomas because a court order authorizing the final bill is a necessary precondition for payment. This court should reverse and remand with instructions to approve the final bill because there is substantial evidence in the record to show compensation is reasonable. No further development of the record is needed. I'd also like to hit on what counsel said about the median of the state public defenders' similar fee claims. The mean of those 4 claims was $13,500, which was well above what Casey requested in this case. I also want to touch on the fact of the juvenile court's October 11th order, which indicated it needed up to 60 days to research and issue its ruling. Pierce v. Nelson simply gives juvenile courts the framework so that they don't have to spend 2 months to research how they should analyze expert compensation. They can go.
Person standard, why should we not let the district court be the one to apply it first?
Court did have an opportunity to apply Pierce. It was raised in Casey's memorandum on September 18th, and the juvenile court failed to acknowledge the Pierce test. As a matter of...
If we tell the juvenile court to apply that test, I believe that the juvenile court will do so. So I think that there is a concern to some extent that the district court is kind of the gatekeeper of what is reasonable, and it does seem like that they should get that chance to apply that.
Again, I would say that they did have that chance. They had all the substantial evidence before them, even in their subsequent rulings where they had even more information, whereas in their original order, they were kind of looking into the future and dealing with the estimates of Dr. Thomas. At the end of the hearing, they had the actual invoice and the actual expenses, and they failed to even engage with that new evidence, including the fact that trial was continued to a second day, which was not in the initial estimate. Now I'd like to clarify my response on the juvenile lens question from Chief Justice Christensen. The standard is reasonableness, and the test should be Pierce. A juvenile lens relates to the application of that test. Reasonableness is fact and context specific. Youth is an important consideration when looking at reasonableness of expert services. For example, it may be reasonable to ask an adult with a driver's license to drive 45 minutes to an evaluation, but it's not reasonable to ask a teenager who does not have a driver's license to drive. We're not asking for a separate...
The state probably questions that I am very much so interested in juvenile law and making sure that the youth of Iowa are treated fairly and appropriately. But I'm still struggling, if you can't tell from my questions, I'm struggling with why we need to notch it up just a little bit more. There are other groups of people that would very much so like to have their own lens as well. Why can't we just leave it up to the discretion of a judge? A judge is a smart person. They're going to look at this audience, what's before them, and say, okay, maybe, and why can't they, for the same reason you just said, okay, the kid is probably 14 years old, obviously can't drive, makes sense to maybe have the expert travel. In this case, that kid's going to get a little more bang for his buck, whereas a grown-up can get him or herself there. Why do we have to have it said that it's a lens, and why can't we just continue with discretion?
My time is up. May I answer your question? Well, I would just say that, again, the acknowledgement of a youth-centered lens is just to instruct juvenile courts to make those unique considerations. Here, the court did not engage with the evidence which suggested it was reasonable for Dr. Thomas to come to KC so that he was in a comfortable environment where he could give full and honest answers to help the juvenile court's determination. We would ask this court to reverse and remand with instructions to approve the full fee, and we would also ask this court to adopt the Pierce v. Nelson test. Thank you.
KC versus Iowa District Court for Polk County is hereby submitted, and court is adjourned for the afternoon.